What's the first element? What's the first element? What's the first element? All right, defamatory language. What's the second? Well, I'll just help you out here in the interest of time. So there has to be defamatory language, right? That is, and key to that element is the assertion of an express or implied false fact. So defamatory language, that language must be of or concerning the plaintiff. That is, it has to be about the plaintiff. Third, it has to be false. Fourth, it has to have been published, meaning it was disseminated to at least one third person who understood it in its defamatory sense. And also, where we start tonight, it must have damaged the plaintiff's reputation. And here we need to make a little distinction between libel and slander. Everything that we've talked about the last 2 weeks applies equally to libel and slander. But with this element, number 5, we need to make a distinction between the two. Basically, libel is a defamatory communication that is written form. So if you can see it, the courts are going to characterize it as libel. And that'll be important for reasons that will be apparent here in just a second. But so, newspaper, book, letter, anything that can be seen with the eye. Radio and television broadcasts are generally treated, most of the time at least, as libel because broadcasted material, more often than not, has at least some genesis in a writing, in a script of some sort. Now, if the broadcast is truly live, some jurisdictions treat it as libel, some treat it as slander, but be that as it might, once the form of the communication is libel, any repetition of that, even if it's oral, it's treated as libel. So, simply put, once libel, always libel. Slander, on the other hand, is different. Slander, if you can hear it, the courts are going to usually treat that as slander, and the written repetition of slander will be treated as libel. So once libel, always libel. That's not the case with slander because the written repetition of slander is to be treated as libel. Now, with this little distinction in mind, what must be shown to establish damage to the plaintiff's reputation? Let's deal first with libel. The majority of courts hold that if the libel is defamatory on its face, so it's libelous per se, and by on its face I mean you can just take the words that are that are written, ignore everything else, and conclude that communication is defamatory, that it reflects unfavorably on the plaintiff. So that is libel per se. The majority of courts take the approach that with that kind of libel, damage to the plaintiff's reputation will be presumed. So the practical significance of that is that the plaintiff doesn't have to prove actual harm, doesn't have to prove special damages, for example. And doesn't that take us all the way back to the beginning of the year when we talked about damages? You remember special damages, those being pecuniary or economic in nature, something to do with the loss of money. So in this context, in the context of defamation, special damages might take the form of lost profits, in the case of a business, loss of customers, maybe in the case of an individual, losing a job, losing a prospective inheritance because of the defamatory communication. There's some sort of a economic or pecuniary harm. Those are special damages. Well, in most states, if the libel is libel per se, by operation of law, it's presumed that the plaintiff's good name and reputation has been damaged. Tennessee does not follow the majority rule. In Tennessee, we're a part of a small handful of jurisdictions that requires the plaintiff to prove actual harm in every defamation case, period. So the plaintiff is going to have to show not necessarily that they've suffered special damages, although if they can, so much better for the plaintiff, but they are going to have to show that they were, that in some way they suffered real harm because of the libelous communication, whether it's per se or not. But that's not the rule in a majority of jurisdictions. The other type of libel is called libel per quod. That is, it's not defamatory on its face, and the plaintiff does have to resort to extrinsic facts and circumstances in order to prove up the defamatory meaning. If that's the kind of defamation before the court, here the jurisdictions are split. Some jurisdictions will say, well, damage or harm to the plaintiff's reputation is presumed. Other jurisdictions, about an equal number, take an opposite approach. Again, though, in Tennessee, this is largely just academic because in our state, the plaintiff must prove actual harm in every defamation case. So that's the rule when it comes to libel. As far as slander is concerned, most jurisdictions require that actual harm be proven, but there is an exception for slander per se. Slander per se actually consists of 4 categories or 4 types of a defamatory communication. The first has to do with a defamatory communication that affects the plaintiff in his or her business or trade or profession. In other words, the defamatory communication affected the plaintiff's ability to make a living. That is a type of slander per se recognized by most jurisdictions as, if you want to think of it in these terms, waiving the requirement that the plaintiff actually prove damage to the reputation. In other words, harm will be presumed. So that's the first type of slander per se. The second is kind of, well, the second one involves a defamatory communication that the plaintiff has what the cases call a loathsome communicable disease. Loathsome communicable disease. And the interesting thing about this particular type of slander per se is that most courts have limited it to just 2 types of diseases. One is sexually transmitted diseases, and the other is leprosy. That's right, leprosy. I guess I never realized that leprosy was a thing, or much of a thing, at least in this part of the world, certainly in the United States. But the cases say that if the defendant has made a false accusation that somebody has leprosy, that person doesn't have to prove actual harm to his or her reputation. The third instance where actual harm need not be shown is a false accusation that the plaintiff has committed a crime involving immorality, or maybe more accurately, you see the phrase in the cases, moral turpitude, a crime involving moral turpitude. Child sexual abuse, for example, bigamy, for example, incest, for example, a crime involving moral turpitude. And then the fourth one is a defamatory statement that imputes falsely sexual misconduct to the plaintiff. The interesting thing about this one is that in many jurisdictions, a distinction is made between male and female plaintiffs. So a false accusation in some places that a female plaintiff has engaged in some sort of sexual misconduct relieves her of the burden of proving actual harm. That is, harm will be presumed. But the same allegation made against a male plaintiff doesn't have the same legal effect. That is, a male plaintiff would have to prove actual harm to his reputation. So, as you might imagine, there are equal protection issues with that. Some jurisdictions, as this issue has come up in more modern times, have done away with the distinction between male and female plaintiffs. But traditionally, that line has been drawn. Whether it's a good thing, bad thing, I guess that's a matter of opinion, but it is a thing. And it's the fourth type of slander per se. And then there is maybe one other category which the court in Ward took up. That is a false accusation that the plaintiff is a racial or ethnic bigot. So let's talk about Ward versus Zelikovsky. Miss Epstein, tell us about this one.
Okay, Ward versus Zelikovsky. The Wards, husband and wife, and Zelikovsky own separate condominiums at the Ocean Club in Atlantic City. During a condominium association meeting attended by 100 residents, Mr. Ward addressed the board, and then Mrs. Ward stood to speak.
Which is about the size of this group right now. So if you can imagine an HOA meeting about this size is taking place, and what happens?
So Zelikovsky then jumps up and says, quote, "Don't listen to these people. They don't like Jews. She's a bitch. These people hate Jews. These people hate Jews." The statements were unrelated to the meeting or what Mr. Ward had discussed. Mrs. Ward later stated that this made her feel embarrassed and distressed. And Mr. Ward testified that the accusation harmed his reputation and business prospects.
Did Mrs. Ward, did she have any special role that she played in the homeowners association?
She was part of the Sunshine Committee, so she did like welcome letters to new residents. So she was very aware that they had a large Jewish population.
Okay, so actually she was the head of the Sunshine Committee. I think at some point in all of our lives, we ought to be the head of a Sunshine Committee. Well, the meaning though, she's out there, right? People know her. She's not just another homeowner or condo owner. She's got a leadership role in this association. People know who she is. They get cards from her. They get letters from her. Communications from her. And the business that was being discussed had absolutely nothing to do with her. And as you point out of the blue, the defendant just stands up and says what he says. Maybe you said it and I missed it, but how did she make her living? What did she do?
She's a realtor.
She's a realtor. So she's got a job that requires you to be out there in the public, to be visible. Well, what was the factual basis for the defendant's statement that the Wards hated Jews?
So a third party, Sheila Poland, I believe, had told him that they had made anti-Semitic remarks, but she didn't remember exactly what they were.
All right, so he had no factual basis. He didn't hear these people say anything. He was just told by somebody else that person overheard. And then that third person was asked, and what was her response?
She didn't remember.
I don't remember what they said. I don't know. Can't help you there. The Wards sue for defamation. What were they able to prove in terms of damages?
So they couldn't prove any, I think they were asking for compensatory damages, but all they proved really was that, I think they kept saying, quote unquote, their coolness was affected. I think he made comments that he was looking at real estate, he didn't feel comfortable doing that anymore because of the large Jewish population, but that could harm him there. They weren't invited to social events anymore.
So they weren't able to prove special damages or actual harm, right?
No.
And that sets up the legal problem here. The case is tried. What's the jury decide?
So they found that there was slander, and that they had sustained special and general damages, but the amount of damages was zero. So then they wanted to award each of them punitive damages of $25,000. Then they had to go back because the court reminded the jurors that punitive damages cannot be awarded in the absence of special damages. So I think they assigned like $1, like very nominal damages.
Isn't that interesting? So the jury finds that the plaintiff suffered no compensatory damage, no harm to their reputation, zero. But yet they don't like what the defendant did and wants to punish him and thus award each plaintiff $25,000 in punitive damages. And they report that verdict to the trial judge. The trial judge says, as you point out, you can't do that. You can't award punitive damages absent an award of compensatory damages. So the jury says, fine. We award each plaintiff $1 and each now $25,000 in punitive damages. The trial judge says, okay, sounds good to me. And this case goes up on appeal. What's the issue? What's the question here?
There's a few. Well, did Selakoski's statements, did they constitute slander per se? Was there sufficient evidence of special damages to support the defamation claims? And were the punitive damages appropriate given the evidence presented?
Or maybe just to pull out a little bit, more generally, the question is whether a false accusation that somebody is a racial or ethnic bigot is a type of slander per se that relieves the plaintiff of the burden of proving actual harm. What's the answer?
So yes, so the court said that the four categories for slander per se were archaic, essentially, and that racial or ethnic hatred is equally damaging to a reputation. The statements were malicious, they were in a public setting, there was no evidence to support them. They were so injurious that the court will presume without proof the plaintiff's reputation has been impaired.
It certainly is, at least it's as damaging, the argument goes, that somebody has leprosy. There's a dissent in this case. What problem does the dissenter have with what the majority has done?
I didn't write this down, but I think that he was saying it was really just words, so they shouldn't be able to recover for that.
Well, it's always just words, isn't it?
Yeah.
Well, according to the dissent, calling Mrs. Ward a bitch is just name calling. It's no different than butthead astronomer, right? It's no different. It's worse. It's uglier, but it's still just name calling. That's not tortious. That's not illegal. Stating a false fact about somebody is. But name calling is protected speech. And so the dissent argues there should be no liability for referring to her using that word. As far as the other words that were used, that is, these people hate Jews, in quotation marks. The dissent argues that's a statement of opinion. I mean, that's just this guy's opinion. That's just his view. That's not a false assertion of fact. That's just somebody's characterization of these plaintiffs. Who do you think has the better view, the majority or the dissent?
I'd say the majority.
Where's the false statement of fact and what he said?
I guess there's not.
Okay.
But
If there's no false statement of fact, seems to me that should take care of the case right there.
the court did pay special attention to the persecution of Jews during the Holocaust. And so I think.
And the dissent pointed out that the defendant was a Holocaust survivor. Maybe, maybe not. That had something to do with him, just standing up out of the blue and saying what he said. But that, at least it adds some interesting context. But I guess the problem I'm having is if you can't put your finger on a false fact, express or implied, that should be protected speech. That's not tortious. Anyone disagree? Where's the false fact here? Yes, sir.
Is it defamatory to accuse someone of being a liar?
Is it?
I would say that my line of thinking is that that is a character trait, which is as much a fact as a physical trait. But accusing someone of being a bigot is a trait of character, just as much as being a liar would be.
Okay. But being a butthead astronomer is not a character trait? Being a butthead is not a character trait?
Saying that someone is disagreeable or has an ego is not the same as being a liar or a racist.
I think the point of this discussion is you see how difficult it can be for the courts to draw these very fine lines. Because we can come up with endless examples that are just gray. I guess you can make good arguments on both sides, and that's why you put 12 reasonable people in a box, explain it all to them, and then they make the judgment call. What's the bottom line as far as you're concerned regarding this case? You put this one in the drawer, step out of some of these nuances. What does this one teach you about the law that you just didn't know?
I mean, typically defamatory statements require proof, but here they didn't, so I don't know. I mean, my takeaway was just really be careful what you say, but that's not a.
Well, at least in some jurisdictions, I think the takeaway would be that a false accusation that somebody is a racial or ethnic bigot is a category of slander per se that relieves the plaintiff of the requirement to prove actual harm. That harm will be presumed by operation of law. Thank you, ma'am. So, assuming that there is damage to the plaintiff's reputation, whether that is presumed or whether it has to be proven, like in Tennessee, every single time in Tennessee, I say again, every single time in Tennessee, what damages can be recovered? Well, certainly compensatory damages. So embarrassment, humiliation, emotional distress, like in the Ward case, a marked coolness. People shun me now because of the defamatory communication. My friends have stopped communicating with me. I'm not getting invited to things that I used to get invited to because of the defamatory communication. So the jury can put a dollar value on all of that and make it part of a compensatory award. Also, special damages, if there are special damages, can be awarded. Again, loss of a job, loss of customers, lost profits, loss of a prospective gift, maybe an inheritance. If that's the evidence, the jury can assign a dollar value to that and make it part of the award. And then the third category, which is always a wild card in these cases, is punitive damages. But because liability, in essence, punishes speech. Punitive damages can only be awarded if the defamatory communication was published with malice, which in the context of defamation has a specific meaning. That is, the defendant actually knew that he was publishing wrong information about the plaintiff, or he did so recklessly. So he actually knew it, but did it anyway, or he did so recklessly. That is, he didn't know that it was true or not, he just put it out there. So that's the fifth element of defamation, damage to the plaintiff's reputation. The sixth element is a fault standard. The U.S. Supreme Court, in construing the First Amendment to the Constitution, has imposed various fault standards that the plaintiff has to meet in three categories of cases: those involving public officials, public figures, and where the communication at issue is something that is, quote, newsworthy, whatever that means. But those are the three categories that the U.S. Supreme Court has said require the plaintiff to prove a certain fault standard. Well, the states are free in interpreting their own constitutions to raise those fault standards, to make it even to make it even more difficult for a plaintiff to recover in those three kinds of cases. What the states can't do, though, is to reduce or make less strict the fault standards imposed by the U.S. Supreme Court. So I like to think of these fault standards that we're about to discuss that have been adopted by the Supreme Court as a floor, but not a ceiling. The states can raise them up, but the states can't lower them. Let's deal first with public officials, and why don't we go right to the Ferguson case for our discussion of public officials and the fault standard. Ms. Hutchins, I believe, you're going to tell us about this one? Oh, that's right. I'm sorry. Mr. Bullington?
So we got Mr. Clifford Ferguson. He was a longtime employee of Louisiana County. I don't even know what that's at. We'll go with it.
Obion County is the northwest corner of Tennessee.
Awesome.
Very rural area.
Gotcha. He served in various financial and administrative roles. He did almost like a purchasing agent, if you will, with substantial authority over kind of the county's financial operations, procurement, bid evaluation, co-signing payment warrants. There was a newspaper in the area that published some articles about him. This was the Union City Daily Messenger. They had written some articles essentially attributing the responsibility or the reasoning of the county's failure to timely pay their bills, specifically to Ferguson. These articles attracted a lot of attention and suggested that Ferguson was effectively responsible for the county's financial disarray, including all the late payments and penalties incurred.
What were the penalties that were incurred?
Write that down. Find a friend. Anyone's got that?
Just remember there were late fees, their credit got taken away, so they couldn't have credit fees anymore.
Anybody remember the amount of the late fee on some utility? Yes, ma'am. What was the amount? $250, which in the grand scheme of things, in terms of a county budget, really that's nothing. Not a big deal. $250. What is a big deal is that because the county had not paid its bills on time, the state suspended the county's credit. That is huge. And so all of this becomes public. The local media gets a hold of it, writes this story. And as a result of the story, the plaintiff says he was fired. He sues for defamation. What does he claim that the paper did wrong?
Basically, that they mischaracterized his role and authority in terms of what he was supposed to do with those payments, stating that it was really another employee that was responsible for preparing those payments, basically pointing the finger at somebody else.
Yeah. And who was the someone else? According to the article in the paper.
Did not write that down.
Anybody? The article referred to, oh, sorry. Yeah.
They said, the article said it was his secretary, but he said they were co-employees.
Okay.
So ultimately, he lost his job, and he alleged that the publications themselves was really the reason why he lost his job. Went to court.
Well, hold on. Let's finish up thinking about his argument here. He has to prove a false fact, right? I mean, he has to prove a false fact. So he says one false fact in this article was that this coworker who functions, he admits, as his quote secretary. She's his assistant, but it's actually part of her job to write the checks, and she was out on maternity leave. And so these bills piled up on her desk, and therefore it's her fault, just like you said. But the false fact, according to him, was the paper got her title wrong. She was not his secretary, although, again, he said she functioned just like my secretary. Instead, she was a coworker. So that's factually false. He also argues that the paper got his title wrong. You messed up my title, my job title. Therefore, you're liable for defamation. The first issue in this case, and it's the reason that this case is significant legally, is what's the false standard that a plaintiff like Mr. Ferguson has to meet as a public official? What is that false standard?
Oh, you asked, sorry. Whether or not he qualified as a public official.
No, what's the false standard?
Sorry.
Whether he's a public official is the second issue. But what's the false standard?
Was there an existence of malice? Not sure what you're asking.
Well, you're not sure what I'm asking. I'll try again. What is the false standard that someone like Mr. Ferguson is held to in a defamation case?
Well, I think maybe I'm misunderstanding. I would think initially his thinking was he's a private person, and so, but this whole case is really centers around whether he's a public official or not. I mean, I'm missing what you're getting at.
No, I don't think you're missing it, but so what is the fault standard in Tennessee for a public official?
Oh, clear, convincing standard?
No.
Okay, I'm totally missing.
You were on the right track initially.
Well, malice is required.
Yes.
Okay,
There you go.
okay, sorry.
Now, here's the harder question. How'd the court get there? Remember, the U.S. Supreme Court standards are a floor, they're not a ceiling. And this case requires the Tennessee Supreme Court to construe the Tennessee Constitution, not the federal Constitution. So the court could have taken whatever the federal fault standard was and make it even more stringent. The court just can't lower it. So how did the court get to this fault standard?
They kind of walked it under, they started with New York Times, George Sullivan, talking about public official may recover for defamation only under clear and convincing evidence that defendant acted with actual malice, not knowledge of falsity or reckless disregard, like we talked about before we got into this, but then adopted that standard through Press Incorporated v. Barron, applying the restatement 588 to public officials, and basically defining the public official as.
Stop there.
Okay.
That's the second issue. Let's nail down this first one. So the court is having to interpret or construe Article 1, Section 19 of the Tennessee Constitution, which says in part, the free communication of thoughts and opinions is one of the invaluable rights of man, and every citizen may freely speak, write, and print on any subject, and then here's the key part, being responsible for the abuse of that liberty. The question here is, what does that phrase, being responsible for the abuse of that liberty, mean? The court concludes that it means the same thing that the Supreme Court in New York Times found construing the First Amendment, which is malice. And that showing does have to be made by clear and convincing evidence. And the court defined malice, that is, with knowledge of falsity or with reckless disregard for its truth. So malice is a very high standard, and it's difficult to prove, except in the most egregious of cases. Clear and convincing evidence, something more than a preponderance of the evidence. That's the New York Times standard, and the court in Ferguson adopted that as part of Tennessee's common law construing the Tennessee Constitution. Okay, that then leads to the second issue here, and that is, what is a public official? What is a public official?
So a public official would include any government employee who has or appears to have substantial responsibility for or control over government affairs.
That's it. That is the definition of a public official. Somebody that has or appears to have significant control over some aspect of a governmental function. That leads to the next issue. Was this plaintiff a public official?
Under their reasoning, yes, even though there may have been a little bit of disagreement or lack of clarity, so to speak, around what his job was or wasn't, but he essentially was, for purposes of this, a public official.
What was it about his job that made him a public official?
Well, I mean, he exercised substantial control over a lot of the financial stuff, in some capacity.
That's right. He was in charge of the county's finances. He paid all the bills for the county. He was the purchasing agent person for the county. He was in charge of the money that comes in and goes out. court therefore has no trouble finding that he's a public official. That then leads to the last issue in the case, which is whether Ferguson, as a public official, required to prove malice, was able to do that. Did he prove malice?
They were minor, non-material, insufficient. It's just
So
not
was he able to
constitutional.
prove malice? No. But they got his title wrong. And the court's response was, the court said it in a nice way, we're not going to get caught up in the niceties of job titles. My paraphrase, what? You want us to impose liability in a defamation case because they got your job title wrong? Case dismissed.
Kind of reminds me of what my employer says about our titles and what we actually do. It's like, oh, we don't really care what your title is. We can give you this to do regardless. So, whatever. You know, it doesn't really matter what your actual title is. It's kind of my takeaway of what they kind of said at the end of this for that.
And same thing with the reference to Miss Bond as his secretary. The court basically said, so what? You're wasting our time, plaintiff. Case dismissed. What's the takeaway for you? What does this case teach you about the law that you didn't know?
Well, I think I kind of alluded to it, you know, that really that notion of functional authority, you know, what you actually do versus what they actually call you on paper, you know, doesn't always make a hill of beans when it comes to adjudicating things like this. So, devil's always in the details, gray areas, things that I saw.
The devil is in the details, but with this one, I think the big takeaway legally is that if the plaintiff is a public official, he or she must meet that very high malice standard. That makes it so hard for a plaintiff like this to win. And it's because of concerns over, you know, free speech. Thank you, sir. What if the plaintiff is a public figure, not a public official, but a public figure? By the way, do we have any school teachers in here? Anybody? Okay, we want only one? Usually we've got quite a few. You're a public official, by the way. Anyone that works in law enforcement? Any police officers? I know we have some. Okay, yeah, one. Just one? That's unusual. Okay, you're a public official. Anybody ever been had a leadership role, specifically the president of a homeowners association? Anybody? Well, some of you are a little timid about raising your hands, but congratulations, you're a public official. Don't leave the Ferguson case thinking that a public official can only be this, like, you know, really high-ranking figure in state or federal governments. It's like the definition says, anybody that has or appears to have control over some governmental function. And the courts have held that police fall in that category, teachers fall in that category. We could come up with a pretty long list looking at it through that lens. Yes, ma'am.
Good evening, Judge. I'm just curious, are military personnel public officials or only certain ones?
I don't know if a court would say every person in the military would qualify as a public official. Maybe some court somewhere has so held, but certainly, certainly your higher ranking people would be. Yeah.
On that topic, CAF, the criminal appeals of armed forces, they wrote on that exact issue. You have to be working in the office you're appointed to. Typically for higher officer or officials, but it's specifically to the role that you're appointed to.
And even if you're not a public official, what might you be? Might be a public figure. And that takes us right to the next category here. The courts have found that all over the country that there are different ways for somebody to be tagged as a public figure. One way is for the person to have gained such fame or notoriety that they're a public figure for all purposes and all contexts. A president, for example. A governor, for example. Tiger Woods, for example. It's been in the news a good bit lately. Famous actor or actress, somebody that's really well known, is that they're public figures for all purposes and contexts. And then there are what are called limited purpose public figures. These are plaintiffs who either voluntarily or have been involuntarily pulled into a specific controversy. So they were a private person, but then they got caught up into something much bigger than themselves, and now they're in the news. Can you think of an example? How about that? So in the Spence case, you saw another instance where Larry Flynt decided to open up both barrels in a very public way against the plaintiff, Jerry Spence, who was, and really still is, but certainly was at one time, a very well-known lawyer. They participated in all kinds of high-profile cases. Well, one of them involves representing a plaintiff in her lawsuit against Hustler Magazine / Larry Flynt. And you saw what Flynt had to say about this lawyer. Lots of ugly language. Spence sues for defamation. And the question is whether a lawyer who is representing a client in a high-profile case becomes a public figure by virtue of doing so, and therefore must prove malice. You see, that's the legal significance of these labels. So if Spence is tagged as a public figure, he's got to prove malice, which would be very difficult to do given the content of the defamatory communication. But if he's a private person and only has to prove negligence, well, that's easier to do. So my question to you all is, what did the court hold and why on that issue? Or at least the majority of the court. The court was split, right? But what did the majority find? Was Spence a public figure or no? So if you take on a client in a high profile case, does that make you a public figure? Such that when some reporter or some media outlet just, just says very ugly things about you publicly, are you going to have to prove malice? Was Spence a public figure or no?
He's not an attorney who is merely advocating for a famous or controversial client. He's not a public figure merely because he's taken on the cause as an actor.
The dissent argues that Spence had made appearances on numerous television spots, given lots of interviews, broadcast nationally on TV and also on radio. This lawyer was out there in the public eye, and the dissent says, as a matter of law, he is a public figure. The dissenters also argue that if you strip away all the vulgar language, there's nothing left. In other words, there is no false statement of fact, no defamatory language. Lots of ugly things, yes. Lots of name calling, yes. But remember, that's not tortious. Stating a false fact is. Maybe the harder question, is why was the court reluctant to hold that Spence was a public figure as a matter of law? What was the reason for not going all that way? Anybody? Yeah.
Lawyers were both figured just by representing a client that it would potentially chill, actually like advocacy and reminding a part of clients, with the famous clients well known to take lawyers for.
That's exactly right. Court did not want to create a situation where lawyers were reluctant to take on high profile or unpopular causes or cases. And that was the basis for the majority's decision. Big picture here, though, is like a public official, a public figure is going to have to meet that malice standard by clear and convincing evidence. And then there are plaintiffs who don't fit in either of those categories. They are private person plaintiffs. And in the vast majority of jurisdictions, the fault standard is negligence. And that's true in Tennessee as well. Let's talk about some defenses now. Those are the 6 elements that make up a defamation case. And it's only taken us 2.5 weeks to get through it. There's a lot to each one. As far as defenses, we can go through these, I think, fairly quickly. Certainly if the plaintiff consents to the publication at issue, there's no liability because consent destroys the wrongfulness of the defendant's conduct. So if the plaintiff has acquiesced to that defamatory communication having been published, that is a defense. Also, we've talked about this second one some, but just to make the point explicit, the truth of the defamatory communication is an absolute defense. Truth is a defense. And recall too that at least in Tennessee, the plaintiff bears the burden of proving falsity all the time. So falsity is part of the plaintiff's prima facie case in our jurisdiction. And that's true in the majority of states as well. But truth is a defense. Even if the communication destroys the plaintiff's good name and reputation. Even if the communication was made out of hatred or spite. Or like in the Hustler case we looked at last time, where Larry Flint testified that it was his objective to assassinate Falwell's character. If it's true, there's no liability for that. Truth is an absolute defense. Some states, a lot of states actually, have what are called retraction statutes, the essence of which limit a recovery, or at least limit the types of damages that can be awarded if the defendant issues a retraction, or a correction. They publish a story, then they learn, oh, there's some false statements of fact in here, and they promptly issue a correction, an apology, a retraction. And depending on the language of the statute, that can either preclude a recovery outright in some states, or at least limit the kinds of damages that can be recovered. So just know that there are these retraction statutes out there. There's another defense, another privilege, if you want to think of it in those terms, called the judicial proceeding defense or judicial proceeding privilege, where all statements, whether they're defamatory or not, all statements made by the judge, made by the lawyers in the case, made by a witness who testifies, made by the parties to the case themselves, those communications are absolutely privileged under this judicial proceeding privilege. But what about a lawyer who's just advertising for business? Does this judicial proceeding privilege or litigation privilege, does it extend to lawyer advertising? That's the question that the court in the Simpson Strong Tie versus the Stewart case takes up for us. So, why can't I even find my list here? Miss Lynch. That's what happens when you write 100 people's name on one piece of paper and you have arrows and everything going all over it. But I figure with just 2 weeks left, I'm just going to ride with this instead of starting over with something clean. But that's while I'm fumbling to try to find a name. Floor is yours.
Okay, so in Simpson Strong Tie Company, a California corporation with a manufacturing facility in Gallatin, Tennessee, they design, manufacture, and sell metal connectors and screw fasteners, which are used in wood frame construction, including screws specifically designed for outdoor wood decks. And then Stewart, Estes, and Donald, a Tennessee law firm, sought to solicit potential clients for litigation involving allegedly defective screws. In January 2006, the firm placed a newspaper advertisement in the Tennessean newspaper stating that individuals whose decks were built with certain screws manufactured by Simpson Strong Tie and others may have certain legal rights and could be entitled to compensation or repairs. They asked people to call if they would like an attorney to investigate a potential claim to them. The firm also posted a similar statement on its website announcing that it was investigating corrosion issues in screws and fasteners manufactured by Simpson Strong Tie. And then a person who
Well,
responded,
back up one step. Okay, well, go ahead.
a person responded to the advertisement, allegedly contacted the firm and was told by the firm that the Simpson screws were defective, would rust, and would break, and would also cause the deck boards to come loose.
But on the website, I don't think you mentioned the most problematic language, and that was that we're investigating the accelerated corrosion due to defectively manufactured screws and fasteners. Defectively manufactured. And so the plaintiff argues, you're alleging that our product is a defective product. And so we have this lawsuit. What's the issue here?
So, the issue is, does the absolute litigation privilege apply to communications made preliminary to a proposed judicial proceeding where such communications are directed at recipients who are unconnected with the proceeding in hopes of soliciting them to become parties?
That's a nice, thorough legal way of saying what?
Of saying, does the absolute litigation privilege protect lawyers who are soliciting potential clients?
Yeah, does it extend to lawyer advertising? Is the judicial proceeding privilege or this litigation privilege, is this something new to Tennessee law or the common law in general?
I don't think so.
Court says this is something that's been around for at least 400 years, dating back to the 1500s. And it's been part of Tennessee law since the Civil War. So this is not a new concept. This is one that is firmly anchored in the eons of legal time. But it has to be applied in this modern context of lawyer advertising. Well, the law firm argues that even if what we published is false, even if it is defamatory, we're still not liable because of this absolute litigation privilege, right? What's the court's response and why?
The court says that, yes, the litigation privilege applies to attorney communications if all four elements of the four-prong test are met.
Okay, so what's the first one?
The first one is the communication is made by an attorney acting in the capacity of counsel.
Okay. Would that one seem to have been satisfied here based on what we know?
Yes.
Okay. It was a law firm that put it out there, right? What's the second?
The second one is that the communication is related to the subject matter of the proposed litigation.
Okay, the proposed litigation is a products liability case. It would seem that the language used would fit that. What's the third one?
The proposed proceeding is under serious consideration by the attorney acting in good faith.
We're not really given much insight into that, but I wouldn't think that the law firm would have difficulty proving that. You just put the responsible partner on the stand and, well, was your firm really, really considering representing people that might contact you all as a result of this advertisement? And the answer would be yes. thus satisfying the third requirement. And then what's the fourth one?
The attorney has a client or an identifiable prospective client at the time the communication is published.
Okay, we're not told anything really about that one. But in order for the law firm to satisfy that requirement, what would you ask your client? If I'm the law firm, I'm that partner on the stand, and you're representing me, your defense counsel, what might you ask me in order to satisfy element or requirement number 4? What's the requirement again?
That the attorney has a client or an identifiable prospective client.
Okay, so what's going to be your question to me?
Would you be a prospective client?
No. No, what's the requirement again? Say it again.
That the attorney has a client or an identifiable prospective client.
Okay, so I'm the attorney. You're representing me. You know you have to get proof of this fourth element. What are you going to ask me? I think you're making it. What?
Do you have any clients?
There you go. See how easy that is? Do you have an existing client or
An identifiable client.
there you go. See how easy that is? What if I answer no? Now we're in trouble, right? Yeah. Your Honor, may we recess for lunch while I speak with my client? You would discuss this sort of thing before you get to that point, right?
Right.
So I'm going to ask you this, and I'm going to ask you this, and I'm going to ask you this. So be ready. What do you do if you and I have that conversation before I take the stand and I tell you, I don't have a client or an identifiable prospective client. I don't. And then, okay, go ahead. What?
I was just going to say then it won't work because all 4 have to be met.
Okay, you tell me that, and then I say, well, okay, I do.
I would say that sounds kind of sketchy.
Well, I'm insulted that you called me sketchy. You don't think I'm a trustworthy person. You just attacked my character. You've called me a liar. How would you maybe handle that? And by the way, every single one of you are going to run into this sort of thing. Maybe not in a defamation context, but in other types of cases, divorces, child custody matters, criminal cases. Oh my word. I don't know that General Funk or Patrick would say this to you. Maybe they have, I don't know. But I'll tell you, since I don't have to deal with criminal law. In a criminal case, there are 3 rules to always remember. The first one is your client will lie to you. The second rule is that your client will lie to you. And the third one is your client will lie to you. And so the question is, how do you handle that? So like in our example, I've told you ahead of time what is my truthful answer, but then when you educate me, if you say that, you're going to kill the case, and then I change my testimony. Now you've stepped into the world of ethics, right? Professional ethics. What if you have your client on the stand, whether it's any kind of case at all, any case, and you know your client just told a lie. They just told a lie. what do you do? That's a tough, what's your, I know you haven't had ethics yet, right? Yeah, okay, so it's just what your gut tell you. Just what is your visceral, just, you know that your client just lied in court. What does your gut tell you to do?
Recess.
All right, so you ask for a recess and the judge says, "Counselor, why do you want a recess?" Are you going to lie and say, "I need to use the restroom, Your Honor"? Yeah.
Can you ask for redirection to kind of like redirect the question so that the truth comes out, so that you're not really calling them out?
Oh, so now you're going to prove that your client just committed perjury.
You would want to put as many snakes and curves into the line of questioning to kind of throw the opposite side. Somewhere in there is a lie, but I'm not going to tell you which one it is.
What if your client says before the trial, "I did commit that murder. I did.
You still have to do this.
I committed the murder." And then they get on the stand and they testify, "I didn't have anything to do with this. I'm innocent."
You have to present the facts as the most in that stance.
Go ahead. By the way, thank you. Great job with this case. Did you have any closing thoughts?
No?
Okay. All right. Okay. Thank you. So, yeah, you know your client has lied.
Persuasion. My client's perjury is a crime and urgent correct record. Client refuses, lawyer should attempt to withdraw from representation. All those may not be permitted by the court.
I'll say that again. Look, just paraphrase that. What do you? You can't just remain quiet because you become part and parcel of committing a fraud on the court. And the Board of Professional Responsibility that controls your law license will take a dim view of that. Here's what I'm going to do if that happens to me. The first opportunity that I get, at that recess or whatever it might be, my first call will be to the Board of Professional Responsibility. And they have a designated person there called Ethics Counsel that takes questions from lawyers. When you don't know what to do ethically, you can call this person in confidence. By the way, she teaches here. She teaches ethics here. So you're going to have her either next year or the third year. Third year. Her name is Laura Chastain. And so you would call Laura and you would say, "Here's what just happened. What do I do?" And she'll advise you. When this sort of thing happens with judges, I'm on the other end of that phone call. I just did X. I just cussed somebody out in court. I lost my temper. And I said this ugly thing or that ugly thing. What do I do? You don't have to have all the answers as a lawyer representing somebody, but you really need to know where you can go to get the answer. And that's the Board of Professional Responsibility. You can't just be silent, pretend you don't know that somebody has committed a fraud on the court. That's a big deal. One last question about this Simpson strong tie case. Anybody can answer. Does this mean that the rule that we just talked about with these 4 elements, does this mean that lawyers are just free to arise each morning and defame anybody that they please and hide behind this litigation privilege? Can lawyers just defame people with impunity and get away with it? The court made it very clear. The answer to that is no. A lawyer who does go too far might get sued for malpractice, the court says. A lawyer who goes too far might be sanctioned by the court itself. That does happen. And then the third option is the Board of Professional Responsibility will come knocking on your door, and you never want that to happen. So no, you don't have an unfettered license just to start defaming people in the name of advertising. When you do go down that road, you need to make sure that you stay within the parameters of those 4 requirements. If you do that, you're safe. There is a legislative proceeding and executive proceeding privilege that very much parrots the judicial proceeding privilege. It's just that these defendants doesn't have anything to do with a legal proceeding, a judicial proceeding, but maybe, for example, a cabinet member in state government allegedly defamed somebody by releasing a letter that the target of the letter has defrauded the state by double billing travel expenses. And you saw what the court did there, right? The court extended the executive proceeding privilege to encompass a situation like that. Same thing in the context of the legislative proceeding privilege. That is, all remarks that are made, even if they're defamatory, remarks that are made by state and federal legislators in the, like on the House floor or in a committee meeting, hearing, but not a press conference, are absolutely privileged. Publications that are required by law are absolutely privileged. When I say absolutely privileged, what does that mean? What does the Jones case say absolute privilege means? What is that significance of that word absolute?
Clearly not to be by malice, ill will, or improper.
That's right. Even if there is malice, there's no liability. If the privilege at issue is an absolute privilege, like these we're talking about. So if the public, so if, for example, a radio station or a television station allows a candidate for public office airtime and thereby comes under an obligation to extend similar airtime to an opposing candidate, and then that opposing candidate gets on TV or on the radio and says something defamatory, and the radio station gets sued, there's a defense that's called publication required by law. Communications between spouses are absolutely privileged. So feel free to go home tonight and defame me to your spouse, not significant other, not to children, not to a friend, because that would be an actionable publication. But if it's to a spouse, that is an absolute privilege. And then there are two qualified privileges that I want to mention. Qualified, not absolute. Qualified meaning these have to be exercised in good faith. So if there is malice, these two privileges won't work. Protection of a private interest and protection of a public interest. So the protection of a public interest, just to give you, a private interest, just to give you an example there, let's say that a mother falsely tells her daughter that the daughter's husband was having an affair when he wasn't. Turns out she was flat wrong. Husband sues mother-in-law for defamation. As long as mother-in-law, the defendant, was acting in good faith, she's attempting to protect a private interest, her daughter. That's protected speech, even though it's untrue. Now, if mother-in-law did what she did with malice, as we have defined that, then the privilege won't work. That's what I mean when I say it's a qualified privilege, not an absolute privilege. Protection of a public interest is basically the same thing, except that instead of a private issue, it's a public issue. The classic example here would be a report to law enforcement that say the neighbor is doing something illegal, and it turns out that that is just flat wrong. So I call the police and I say, I think my neighbor is manufacturing meth in her garage. And they get a search warrant, look and there's nothing there. No illegal activity. And then my neighbor sues me for defamation. As long as I'm acting in good faith, not malice, I have this protection of a public interest defense that I could raise. But again, I emphasize these two are qualified privileges, not absolute privileges. All the other ones I mentioned are absolute privileges. So they will be unaffected by showing of malice. We're actually 5 minutes early for once. For once. Make sure I get the roll. I'll see you next time. We'll hit a new subject. I think you'll find it very interesting, invasion of privacy.